Hello, everyone. Thank you for kicking off your new year with Rosa and I today. Happy to see you. Wishing you all a very healthy, happy, and prosperous new year in 2025 ahead. Today's topic is SUM and the insurance issues involved with SUM litigation, arbitration matters. There's a ton of stuff. Rosa and I just talking behind the scenes, spent over an hour alone just chatting about everything, and we're likely not going to get through every question and everything everyone has today, but we're going to do our best. As you saw just now, and as Michelle told you, we do offer complimentary one-on-one Zooms to all of you, members of the bar. So if there's anything we don't get to today or any specific cases you want to run by us, just click on the links and schedule a Zoom with us. And we also have been working with law firms. We offer complimentary roundtable Zooms. So whether you're a small firm or a large firm and you want to gather everybody together with us, we can do a firm-wide Zoom and roundtable and discuss your specific cases in your firm. That's also complimentary. Just reach out to us. All of our information is on our screens behind us. Lastly, there's about 620 of you on right now. If you're not a member of the Academy, what are you waiting for? 2025 is the year. It's the year to join. And once you become a member, and if you're already a member and don't know, there's a ton of benefits in addition to all these great CLEs. So please consider joining. All right. Well, today we are going to talk about SUM or SUM. What is that? SUM stands for Supplementary Uninsured / Underinsured Motorist Insurance. All right. So I'm here to talk about the cases and the litigating. Rosa's here to talk about the insurance issues and the complicated stuff. That's what Rosa does for our firm. All complicated things go to Rosa. So generally speaking, I'm going to give an overview of what SUM is, how it plays out, and there's all kinds of crazy scenarios that happen. I'm sure many of you have these in your practice right now. Drop all your questions in the Q&A as soon as you have them, questions, comments, and we will address them if we can throughout this hour, and certainly try and get to everything in the last half hour after the first hour from 2 to 2:30. So how does SUM work? The concept of it is that injured parties can benefit from having their own insurance. When they're in an accident where the tortfeasor is underinsured, meaning doesn't have a lot of coverage, maybe a minimum policy, but certainly less than what the injured party's own insurance is. And if you're in a situation where you're representing a party and one of the parties is the tortfeasor or a potential tortfeasor and they don't have a lot of coverage, you have to explore the injured party's coverage if you're representing the injured party. As Rosa and I have been talking about since we started this series last year, that it is our obligation as attorneys to explore every possible insurance policy, every possible policy that can cover the accident at issue. Up until now, we've been talking about exploring the tortfeasors or the defendant or the co-defendant's policies. Do they have general liability? Do they have umbrella? Do they have excess? What have they got? And how do you get it? But when you're doing your homework on the case at the outset of the case, and if you represent plaintiffs, it is also your obligation to explore your own client's insurance to see if they have policies in effect to cover them for the accident if the tortfeasor defendant just doesn't have a lot of coverage. All right. And the primary policy that an individual will have and often will have is this SUM policy. The SUM policy is part of the auto liability policy, generally speaking. There are other cases. You can have a boat policy with SUM coverage. You can have an umbrella or excess policy with SUM coverage. Traditionally, what we're going to be talking about and what you see are auto policies. For all of you there with a car with insurance, if you haven't looked at your policy in a while, pull it up, look at the declaration page. On that page, there's going to be a list of all your benefits and coverage. You'll have liability, which is if you injure somebody else, but you're also going to have the SUM. and it'll be spelled out: supplementary, underinsured, uninsured motorist insurance. And there'll be a number there. Usually, you're going to find that that SUM number is going to be the same as the liability number. All right. And that's generally what you're going to have in your policy. And you always want as high a number as possible, right? You want to make sure you've got enough coverage to protect yourself, your family, your assets, and you want to have enough SUM coverage in case, God forbid, you or a loved one in your household is injured and the tortfeasor doesn't have substantial or enough coverage. You'll have your own policy so you can sleep well at night. All right. And the SUM policy is for that purpose. Here's how it works in a basic scenario. Basic, because we're going to get into some complex ones. In the basic scenario, here's how it works. I'm crossing the street. I've got the light. I'm in the crosswalk. The defendant makes a left turn, comes flying through a red light, through the crosswalk, takes me out. I break both of my legs. I go to the hospital. I have a rod in one. I've got a plate and screws in the other. I'm hospitalized for a month. The damages are there, right? We'd all agree that the damages alone is worth more than $100,000 for that case, and it's flat liability. The driver admits it at the scene. I didn't see this guy. I was looking at my phone. It's all my fault. So here you've got flat liability, injuries into the 6 or 7 figures. But guess what? In New York State, the minimum insurance policy is a $25,000 policy. This person is a waiter, has $25,000 of insurance coverage and no assets and nothing else. What am I supposed to do? Well, if my lawyer's doing their job, and I go to them for the case, they're going to say, Andrew, do you have SUM coverage? I'll say, I don't know what that is. You say, give me your car insurance policy. Let's see it. I'll say, okay. We'll look down. Aha, you've got $100,000 of SUM coverage. That's good because it's more than the 25 policy that hits you. So what happens in this scenario is the 25 policy is considered underinsured for my claim. 25 grand is not enough insurance coverage to cover this claim. They are underinsured. So they're going to tender that 25 pretty quickly. We're going to get that 25,000. We're going to get consent from my own insurance company, from the adjuster who we've told in advance, hey, we may need to pursue an SUM claim. Then we're going to say, okay, we got their 25. I have 100,000. How does it work? My insurance company gets a set off. They get to deduct from my policy, from my 100,000, whatever I got from the tortfeasor's policy limits, which was 25 here. That leaves another 75,000 that is available to me to get from my own SUM policy to make me whole with 100,000. That's what my coverage was for, 100,000. Now, if I had, and I do have, because of what I do for a living, I've got SUM coverage on my auto policies, and I have an umbrella policy. I have probably a total of about $5 million in SUM coverage to protect me and my family in this instance. So if the same scenario happened and my injuries were worse, God forbid, I was paralyzed or I died, leaving my my minor child, my wife, with a loss, they would then not be stuck with the 25. They would then be able to go after the 5 million. In essence, reduce that 25, and it would be 4,975,000 to go after. Okay. Now, sometimes it doesn't mean they're just going to write the check and give it to you. You still have to prove your damages. You have to prove that there's no issue with regard to liability. Okay. And if they don't pay, you could either sue them in court, or in New York, you can also file for arbitration. It's the plaintiff's choice, and we'll talk about the pros and cons of that. That is generally the purpose and the way SUM is designed to cover you and the loved ones in your household in the event of an accident with someone who doesn't have insurance or is underinsured. Things get really dicey, though, when you start adding multiple cars into the fact pattern and multiple claimants. And that's when we call Rosa. Because when it gets dicey like that, there's a lot more you have to look at, and there's a lot more that you need to consider. So with that being said, I'm going to let Rosa jump into the weeds here, and we're going to talk about fact patterns, the law, the insurance law, and how it works. Now, before I hand the mic over to Rosa, I am sure if you haven't already, I haven't looked at the Q&A, someone's going to ask about the Uber decision that came down, and someone's going to ask about the fact that American Transit Insurance is insolvent. These will impact potential Uber and injury cases and potentially SUM coverage. We will touch on this if there's time towards the end of this program or in the Q&A or in one-on-ones. We're aware of it. We're going to talk about it if we can get to it. That being said, Rosa, the floor is yours.
Thanks, Andrew, and Happy New Year, everyone. I'm so happy to be here. I just want to go into pulling back and going back to the beginning with SUM, because there's a lot of acronyms in this area, right? So there's UM, which is uninsured motorist. And then back in the day, like prior to 1993, there used to be UIM. There was no SUM back then. And what that was UM was mandatory. It was a very specific endorsement. And then the UIM was the carriers would put together their own respective endorsements. So what happened was in 1993, the legislature came up with what we now know as SUM coverage. And that's also Regulation 35D. In the materials, we included the most up-to-date one as of this presentation of the current reg, and that is the endorsement. It's a mandatory endorsement. That's the endorsement you're going to find in every policy. They can't diverge from that endorsement. That is it. And that's the one that pretty much I see across the board standard usage. Even if, let's just say you have somebody that has a only uninsured motorist policy, their chances are it's probably still the SUM endorsement. But you have to take a look at it, because there is a separate UM endorsement that is just for vehicles that have UM. And then the other little wrinkle is, let's just say that your client's in an accident and there is no coverage at all. They're a passenger in a car. The car doesn't have insurance. The other car doesn't have insurance, and your client doesn't own a vehicle. Now you have no coverage. In that case, there is what is called the MVAC, Motor Vehicle Accident Indemnification Corporation. And that's a fund that you can apply to get up to $25,000 in uninsured motorist limits. And that has its own rules. So part of the reason why I tell you this is if you have a case and you're doing research and you're be careful that you're looking at SUM cases, because some of the cases around that 1993 mark when everything changed, before and after, some of those cases are based upon the old endorsements. So take a look at that and be aware of that. So we're going to concentrate on SUM because that's what we all see. When you look at that endorsement and you can look at the reg, which is the endorsement, it's really only like 4 pages. It's very easy to familiarize yourself with it. And I encourage you all to do it. If you have an SUM case, read it. It's only 4 pages. The first part of that endorsement says, this is what we cover. We're going to cover all sums and insured is legally titled to recover from the owner or operator of an uninsured motor vehicle. And that's like kind of all it says. But then, like every other insurance policy, then there are definitions, then there are exclusions, and then there are conditions. Okay, and that's the same pretty much across the board in most liability policies. So when you look at it, and if you actually read the insuring agreement, that's like here's what kind of coverage we're giving you. It has a bunch of requirements in it, and you need to comply with those requirements. But assuming that you're an insured and that it's an uninsured motor vehicle involved, then you really need to dig into the conditions and exclusions, because there's a lot of little tricks you can get caught up in SUM if you're not familiar with it. So your client has an accident, they come to you, okay, you're going to commence a claim. It's a 2-car accident. They're a passenger in a vehicle, and then there's the other tortfeasor. So the first thing that we always do, which you would do as well, is you go ahead and you're going to get the police report. You're going to look that little code on the police report. You're going to go onto the DMV, find out what insurance company that code belongs to, and then you're going to send a letter to that insurance company saying, we represent this person. we're going to be making a claim for liability coverage. Please disclose your policy limits. Okay, so pursuant to Insurance Law 3420, and this is like the single most important insurance law section that you can read if you're going to read any insurance law sections. 3420 gives you the right to request the amount of the policy limits of the tortfeasor's vehicle. Okay, and the reason for that is because in the old days, what would happen was the plaintiffs didn't know what the tortfeasor's limits were, and then they wouldn't place the SUM carriers on notice in a timely fashion, and then the SUM carrier would disclaim coverage. So in order to avoid that, what the legislature did was they added in the SUM section of the insurance law, they added a provision that says that the carrier needs to disclose their policy limits within 45 days. And basically the time for you to notify your SUM carrier is stopped until they respond to you, okay? However, that being said, I wouldn't wait for them to disclose the limits to notify any SUM carrier. There's really no reason to do that. Really, the first step for simultaneously with notifying the carriers of the actual liability case and asking them for their policy limits, then step two is, okay, let me find out where there's SUM coverage, if there's any in this case, and how much there is, right? So the second important question is, so where do I look for SUM coverage? So when you look at that endorsement, that SUM endorsement, there are two sections that are going to help you figure out where you need to look. The first one is the definition of insured, and the other one is a condition. It's condition 7, it's priority of coverage. And when you kind of look at those two sections together, it gives you almost like a checklist of where you should be looking, right? So the first place you're going to look is the policy covering the motor vehicle that was involved in the accident. That's the first place you're going to look. Then you're going to look for, after that, you're going to look at your client and say, okay, now, do you have a policy where you're a named insured on it, a motor vehicle policy, you're a named insured? And so you need them to look. And again, like Andrew said, don't forget the umbrella coverage, because these days that's very important. And there are a lot of umbrella policies providing SUM coverage these days. Then after that, you're going to look at, is there a policy covering a motor vehicle that's not involved in the accident, where my client is other than a named insured? For example, if the claimant is a resident spouse or a resident relative of somebody else, they could be entitled to SUM coverage. Okay. One of the things that I do want to note here is that I have seen it happen where you have a husband and wife and they don't have the same insurance policies. They have different insurance policies for whatever reason. So always explore that, whether it's a legacy of when they were dating or something, I don't know, but check that out. Make sure that you know all the insurance that they have. And don't just ask your clients, what insurance do you have? Ask the detailed questions. Does your son have a policy? Does your wife have a policy? Is there an umbrella policy? Even if they're not sure, who's your broker? Let me call, give a quick call.
One more to add to that, where we've been very pleasantly surprised, is if you're representing a plaintiff who is in a vehicle that was either owned by their employer, or if they were driving during the course of their employment. Most employers that have policies will have an SUM policy, and those are usually $1 million SUM policies. So that's been very helpful in some cases we've had. So find out if that may apply.
Right. And that was added many years ago now, but that provision, that insured definition was added. That in the old days, that wasn't even in there. So, and then the other one, which is an interesting one, if you are driving somebody else's car and you get into an accident, those passengers could be entitled to SUM coverage under your insurance policy. Okay, so these are all of the different areas where you should be looking for coverage and primary umbrella. Okay, now the other thing that's a little tricky is that when you look at the Reg 35D and the SUM endorsement, all it defines is uninsured motor vehicle. It doesn't say underinsured. It just says uninsured. However, when you read into that, there's definitions. Part of it's a definition of uninsured, and then part of it's a definition of underinsured. Okay, so on uninsured, what are we talking about? The easy one. You get into an accident, the other car just doesn't have insurance, right? Another one is where the insurance carrier disclaims coverage on that car. The other one is what we know as a hit and run, right? So the policy, the UM endorsement doesn't say hit and run. It has that in parentheses, but what it says is that when the insurance on the owner and operator of the other car is not reasonably ascertainable, right? So what does that mean? Clear, if there's a hit and run and the guy takes off, well, you couldn't get the plate, you couldn't get anything. But I have had cases where they get into an accident, the people get out of the car, they're talking and chatting and what have you. Then they say, okay, we're going to go get our information. They get back into their cars, and then one of the people takes off. And I've had litigations and hearings where the court looks at whether or not the insurance was ascertainable. Did you have an opportunity? Could you have just snapped a picture of the plate and then you would have known who it was? And the reason for that is they're trying to avoid fraud, obviously. And again, there's that, and the other issue with, just to keep in mind, and since we have so much material, I'm not going to keep going on this, but there has to be contact for hit and run, and they have to report to the police within 24 hours. Okay, so, and that is only for that one section of the hit and run. So if you, if you have a client or somebody contacts you the day that, they need to report to the police, it says the police or judicial officer or something, but the police is basically where you have to report the accident, and that needs to be done right away.
If you're joining us today via podcast, the first attendance verification code is POD 125. Again, POD 125.
All right, so now we're talking about what is an underinsured vehicle. So clearly, an underinsured vehicle is when, the easy one, the other car has less coverage than the coverage that you have. The trick here, though, is, and this is an area that people sort of confuse, there's something called trigger and there's something called offset, right? So trigger is whether or not you can get SUM in the first place. Offset occurs once you've established that you can get SUM coverage. So a trigger is, excuse me, you compare liability limits of your policy, your client's policy, to liability limits of the tortfeasor's policy. Example, you have $100,000 in liability limits. The tortfeasor has $25,000 in liability limits. There's a trigger. Now you have $100,000 in liability limits. Let's say the tortfeasor has $100,000 in liability limits. No trigger. You don't even get to the offset provisions if that happens. All right. And this is where people get a little bit balled up, and this is called trigger. Where it gets a little tricky is where the amount of the policy, of the tortfeasor's policy, has been reduced because there are, for example, multiple claimants, right? So this is where it starts to get a little bit tricky. However, the reg says that an uninsured vehicle is a policy where the amount of insurance has been reduced by payment to other persons injured in the accident to an amount less than your bodily injury limits. Okay, so now let's give examples so we can, really understand this. So let's just say you have two cars. The other vehicle has $100,000 in liability coverage. You have $100,000 in liability coverage. However, there are four people involved in the accident, and that $100,000 liability policy was reduced to, for purposes of your client now, was reduced, and you only get $10,000. In that circumstance, there should be a trigger of the coverage. All right. So just so you can understand that, and there's a lot of, the law is really all over the place when it comes to trigger and offset, which we're going to talk about in a minute. But that happens all the time, right? We've had cases, Andrew, right, where it's been, our client has gotten less than what the full policy, because there's multiple injured people in the car.
Can I jump in for a sec, Rosa? Because
Yeah.
there was a question about that, and I think this is an area that we see a lot, all of us here. So you need to establish before moving on to SUM that you've exhausted the tortfeasor's policy limits. Now, if it's one-on-one, right? They have 100 policy, you're the only claimant, you have a 300 SUM, you need to get that whole 100 before you can go after your own SUM. You can't take 99. You need the whole 100. But let's look at that same scenario where there's 100 policy on the other vehicle. I have 100 policy, I'm the injured party. And I figure, oh, it wouldn't kick in at all because they're the same. But it turns out that there were 3 people in that other car. They're making claims as well. 3 of them all had surgeries. I didn't. So out of that total 100 policy available, forget about the 100/300. Just assume it's all 100. The 4 claimants, they whack it up 30, 30, 30, and I get 10, right? I can then, that's the trigger event Rose is talking about. Even though I haven't gotten the whole 100, the policy's been exhausted. So as long as the policy is exhausted and you're showing you only got 10, then I could go after my SUM for my 100 and go for that extra 90. And we see that happen a lot. And it's important that you're aware of that because, we had a case just recently that resolved where I believe it was a 50 total policy with 3 claimants, and our client was one of those claimants. Our client had a 250 SUM. We didn't care what our client got out of that 50, as long as that 50 was exhausted amongst the 3 of them. And I think ultimately our client got 20 out of the 50, and the remaining 30 they paid to the others. We took the 20, we then went after the 250, they get the offset of the 20, and that gives us a potential of another 230. So the key is exhausting that existing policy, and if it's exhausted, if that number is less than your own liability and SUM policy, which is usually the same, then you can move forward. Did I get that right, Rosa?
Right, exactly. Exactly. And so that differs from offset, as I've said, right? So offset now is what Andrew's been saying before. If the SUM limits are $100,000 and the tortfeasor has $25,000, the carrier will get a $25,000 offset. So you can only recover 75 from the SUM endorsement. I will tell you that there is a requirement that on the deck page of the policy, it has to have very specific language telling you about the offset. So that's something to look for, because if they don't have it, they don't get the offset. Nowadays, most of the carriers have it. Back in the day, before they knew they had to have it, they didn't have it. So that's just something to look for. The other issue that's sort of an offset issue is the priority of coverage, right? Which is, if you look at the policy, it's condition 7. And so if you find out that you have multiple SUM policies available to your client, the maximum amount your client will be able to recover is the highest limit of any one policy. Because the way that the priority of coverage provision reads is basically all the policies get reduced by the amount that you've collected already. Right? So if you have one policy that has 300 SUM, one policy that has 200 SUM, one policy that has 100 SUM, the max you're going to get is 300. But there could also be an offset of the tortfeasor's vehicle. So it could be even less than that. But just so that you can understand offset. I had a client, a colleague actually call me yesterday with a very interesting scenario, which I thought would be interesting to bring up. And it was basically 2-vehicle accident. His client's in one car, the other car's uninsured. Okay. There's 3 people in that car. The 3 people in that car and his client all make a claim against the driver of his client's car. And that policy, gets basically broken down between the 4 claimants. So now the question to me was, can my client also now go for SUM under the car's insurance that she was in? So if you look at the definition of uninsured motor vehicle in the policy, one of the definitions in there says, well, it tells you what an uninsured motor vehicle is not. It actually says an uninsured motor vehicle is not, and then it goes through what it is not. And one of the definitions, it says, is not a motor vehicle that is insured under the liability coverage of this policy. Okay, so, and if somebody knows the answer to this question, I'd love to see it in the chat. The way that I read that, it's saying basically, if you recover, your client recovers from the policy that they're a passenger in, and that suddenly becomes underinsured because there wasn't enough coverage, then the client can't recover the liability, the uninsured motorist. However, in the case that I just talked about, that's not the uninsured vehicle we're talking about. The uninsured vehicle is the other car, right? So my argument would be, and as a precursor to this, as long as you can show that one vehicle involved in this chain reaction of cars is uninsured, you can proceed with uninsured motorist. Or if you can show one vehicle is involved in underinsured, you can proceed against the SUM carrier, provided that you have the triggers and everything. So you don't have to exhaust all of those other liability policies to get your coverage. Now, it's a mathematical puzzle, right? Andrew and I were going through this earlier. Sometimes it might not be worth it. You may want to just go against the liability, but sometimes you may want to go partially against the SUM, and then you may want to go partially against liability, because SUM is arbitration generally, and that's a very fast process, whereas you all know, litigation takes years and years. So
Rosa, can I give put that into an actual fact pattern
yeah,
that we may see? All right, so let's picture this scenario, everyone. Injured plaintiff is in the back seat of town car. Old Ford Fiesta with a 25 policy gets in an accident with the town car. The Ford Fiesta has no insurance, and there's 3 people in that car. All 3 people are injured, and they're all blaming the town car driver. The injured plaintiff who's in the back of that town car is also blaming the town car driver. So you've got the old Ford that's got no coverage. That triggers SUM because you have a vehicle that's uninsured. The town car, let's say, has $300,000 in coverage, which is a decent amount. So the question is, can you go after SUM if your SUM is only 100? And the answer is you can, because you can show that the Ford, who is a potential tortfeasor, has no insurance. So they're uninsured. So that triggers your policy for the injured plaintiff for the 100. Now, you have a choice to make as the lawyer. Do you want to trigger that and go for the SUM for that 100? Or do you think you're better off going against the insurance company for the liability of the driver of the town car for the 300? Now, you can take, let's say you take the 100 SUM. The kicker there is that if you then go after and you get money from that 300 policy, you have to pay that back to the SUM. So whenever you're signing a release with an SUM, when you're closing out that SUM payment, you are always acknowledging that if a tortfeasor with funds is held accountable and pays you in excess or in place of those SUM funds, they get a credit for it. So if you get 70, if you get 100 from your SUM in this scenario, and then you get 100 from the town car you're in of their 300, the client doesn't get 200. The client would get 0, right? Because you'd get the 100, then the 100 from the town car would be the offset, and you'd end up with 0. So you have to be careful of how you play it. you've got to run the numbers, you got to figure out what to do in that scenario. It may not be worth going for the SUM. It may be worth just staying and going towards the 300. These are things as lawyers that we have to know what's available, know what the options are, make some decisions with your client, advise them of why you're thinking one way or another, get their approval, and proceed accordingly.
And the other thing, just to add to that, that Andrew and I discussed earlier, is that when you're in SUM arbitration, technically the carrier stands in the shoes of the uninsured vehicle. So it's almost like they are that defendant. That's how you have to think about it. So are you going to be able to get liability against that car? Again, I wrote a whole article on this years and years ago. If you can get 1%, right, you get joint and several liability, then yeah, do it. But if there's no liability on that uninsured vehicle whatsoever, then you may not be able to recover uninsured motorists. So it gets a little complicated, but it's, you know, there's the coverage analysis and there's a liability analysis in terms of the end recovery in that circumstance. The other thing I wanted to talk about is the conditions and the exclusions. Let me do the exclusions first, because there's actually a couple of interesting exclusions that have come up in the last couple of years that were not there long ago. So the first exclusion has to do with, if, here's an example, your kid is in an accident and has their own vehicle. All right. And their vehicle has $25,000 in coverage because, you know, you want to, that's what they have. And now they're in an accident, the other car's at fault, what have you, there's an uninsured motor vehicle involved. And now the kid says, oh, wait, but dad's got an uninsured motorist policy. I'm going to go back after dad's policy. There is specifically an exclusion where the person, the insured, occupies a motor vehicle owned by that insured, that's the kid, the son, right? That's not insured for SUM coverage under the policy under which a claim is made. So if you followed that, technically there's an exclusion. The son might not be entitled to recover because he was operating his own vehicle that's not covered under the dad's policy. Now, if you listen to any of our other 3 parts of this Who's on the Hook series, I talked about the timing for exclusions in New York are governed by Insurance Law 3420, and there's this, you know, quote unquote 30-day rule, right? So you have to watch for that. It doesn't mean the son's not going to get the coverage. The carrier has to disclaim, all right? And then on top of that, which I'm going to mention quickly because we're probably not going to get to it, there's a petition to stay phase of which adds a whole other element that doesn't exist in other coverage. So if a carrier has a basis to disclaim coverage, they have to disclaim timely, 30 days. In addition to that, once you serve them with that notice of arbitration and it's got the proper language, there's very specific language, you go into the AAA website and it's in there, they have 20 days from receipt of that document to file a petition to stay arbitration. If they fail to file the petition to stay, even if they disclaimed coverage, you get coverage. So there's a lot of ins and outs and tricks here, but it's not meant to trick, but that's the way the system is. It is, they have to comply with the disclaimer requirements for exclusions, because there's other things we won't get into here. And then also they have to file that petition. So it's a double procedure. So, certainly I would recommend making the claim on behalf of your client.
And if you're representing the carrier, I know that some of my colleagues out there on the defense side are likely on this webinar as well. And my friends that do the defense work for carriers for the SUM arbitration and the SUM litigation, the ones who do it a lot, they know this. And they're going to make sure that although by the time it gets to them, they're not sure if the disclaimer was done, they'll check with the carrier. But I find that the practitioners know, and we usually get a petition to stay forthwith once we serve them with our filing for arbitration. So if you're kind of getting into this area of handling the defense of SUM claims, make sure to be on the ball. You don't want to be the reason that the carrier's coverage that otherwise wouldn't kick in is now kicked in because you didn't petition to stay the arbitration. So to me, I find this fascinating, and Rosa, correct me if I'm wrong. I mean, we've seen it in labor law cases and other cases that there could be policies with coverage that would never have to cover the issue in the claimant in the case, in the matter, if they just were on it and they timely disclaimed as they could under the policy. The policy wouldn't provide coverage, but because they didn't timely disclaim, your client's just gotten coverage. The plaintiff's gotten coverage that never would have existed. It's fascinating how that can happen. So, if you're defending these, you really need to be on the ball and respond very quickly to any letters, any petitions that are filed. Otherwise, you could be exposing your client to paying something that otherwise they wouldn't have had to, and you may not get that business anymore.
Right. Then, so now just wrapping up with the exclusions, one of the exclusions, which is odd because the courts don't treat it like an exclusion, is basically, I think most people know this, that SUM coverage is subject to the no-fault threshold. So just like a liability case, it's the same kind of situation. The other ones, which is two that were added, I don't know when, but they not that long ago, where it's bodily injury to an insured incurred while that person is operating the vehicle as a transportation network company driver. So if you're an Uber driver, Lyft driver, there's an exclusion. And of course it has to be, they say when the app is on and you're waiting for a ride or you're giving the ride. That's basically what it says. That's an exclusion. And then the last exclusion, which was recently added, is if the same thing incurred while the insured is using a vehicle through the peer-to-peer, when they use those peer-to-peer car sharing.
Like Turo.
Right. That's another exclusion. Now, I want to touch upon with a few minutes before we get into other things is the conditions, because there's a lot of important conditions and your client could get knocked out of the box on this. And I've seen it. I've seen it in people who've been practicing for 20 and 30 years. It happens because everyone's busy. And this is what happens. When you get the tortfeasor's vehicle to tender their $25,000 policy to you or whatever it is, you have to ask for consent to settle. All right. And the provision, it's called release or advance. That's what it's called. Like that's what it says in there. And then when you read through, and basically how it works is you have to ask them for consent. And then they have 30 days to make a decision as to whether or not they're going to either front the money to you, give it to you. Here's the $25,000. Don't release the tortfeasor. We're going to go after them. Or they're going to say, nah, forget it. No assets for that tortfeasor. Go ahead and settle. And then you can settle. Or if they're silent, they have 30 days. I mean, I would be very careful on the 30 days that you have like a return receipt on your certified card or something so that you could prove when they got it, but that is basically the process. All right, why would a carrier advance the money? The only reason I have never seen it happen, I have to be honest, in my 30 years, I haven't seen it happen. But many years ago when I did a lot of SUM coverage work on the defense side, the reason would be if let's just say it was an awful accident. Just this person was just driving drunk, reckless, killed somebody. And now there's $1 million in SUM coverage. And on top of that, the tortfeasor had a $25,000 policy and they own a $1.2 million house, right? The carrier might look at that like, you know what? We're going to go after them, So that is really the only circumstance I've ever seen it done. And I've actually never seen a litigation where the carrier takes over for the plaintiff. So it doesn't happen very often, but that's the rule. Release or advance. You have to do it. If you don't ask for it, it's hard and fast rule. There's no leeway. The other thing is you can't stack coverage. So we talked about this on the offset. So if you have multiple SUM policies, we talked about this already, you can't stack them. They kind of all offset each other. That's another one of the conditions, okay? The other issue, is the notice and also cooperation. You have to cooperate with the carrier. They're entitled to authorizations. They're entitled to an EUO. They're entitled to inspect your car. It says it right in there, they're entitled to inspect your vehicle. So one of the things that we used to get into all the time in the old days, which I haven't seen as much of this anymore, is where the plaintiffs would put the carrier on notice, and then the carrier's like, oh, nice, and then they put the paper in their file and then keep going. And they never ask for authorizations or for an EWO or for all this, and then they wait until the litigation's been going on for 2 years, and now all of a sudden the plaintiff comes back and says, okay, I want my SUM coverage. Like, oh, well, now we want an EWO, authorizations, and the courts don't like that because you're delaying the plaintiff's case. So my recommendation to anybody on the defense side of these things is, if they get that notice, you should be asking for this stuff right away in the response letter, which I think a lot of carriers have it now in their systems, that these letters kind of get spit out and they'll ask for, authorizations, EWO, blah, 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 just to preserve the rights. Because there have been cases, there used to be a lot of cases where these things would get thrown out. In the last literally few minutes that we have, I just want to talk about a little bit about the procedures for petitions to stay and the arbitration. The arbitration in a nutshell, and Andrew, maybe I'll let Andrew talk a little bit more about how to handle that in a second. On the petitions to stay, it's like a motion for summary judgment, basically, right? That's how you have to treat it. And so as a defense person filing the petition, there are very specific requirements, and you have to look at if you're not familiar with it, it's tricky. It's CPLR 7503. It's not the insurance law. It's a CPLR, and it tells you how you're supposed to serve them, which is certified mail return receipt requested, filing it, and then taking care of the petition and filing it properly. All right. So you have to follow the rules to file. And it used to be much more complicated before the days of ECF. When you're opposing it, whether you're a plaintiff, defendant, whatever it is, a co-defendant, whatever it is, because sometimes they'll file and they'll say there's other insurance and they bring in the other carriers for the tortfeasor. You really need to treat it like a motion for summary judgment. You need to have your evidence in place. I've seen petitions to stay get kicked out because the carriers didn't include a copy of the policy. I've seen petitions to stay get kicked out because certified copies of police reports weren't in the documents. Treat it like a motion for summary judgment. Don't just disregard it, thinking, oh, okay, it's just a petition. It's a motion for summary judgment. That's all it is. And the great thing about petitions, if you're a young practitioner or you want to get into this area, it's a great way to kind of learn how to do little mini trials, because it's basically a hearing. And so they'll say, here's the narrow issue. It's the framed issue. And you go in, and the only issue you're going to litigate is that one issue. So it's a really great area for, people who want to learn litigation to kind of get into little mini trials. And I'm going to turn it over to Andrew just to talk about a little bit, to get in about arbitration and how you treat arbitrations.
Yeah, I'll try and do it in the next 3 minutes, Michelle, so you can do the final poll. So generally, we almost always in New York State will pursue arbitration for no fault. And if we get a sense very quickly that they're not tendering the policy or a substantial part, if we can't settle it, we're filing our petition. You have to do it with the AAA. And if you've never done it before, it's a pretty streamlined process. That's why we like to do it. It's a lot faster than suing them and getting in the rabbit hole of the court system. So you will randomly get assigned the arbitrator. You'll have an initial meeting with the arbitrator by phone. Usually you go over what it is. And then most arbitrators will, sort of set forth a discovery schedule, get everything done by this date. And you really need to stick to those dates. The AAA actually has printed rules, which is great. And the arbitrators will stick to those rules for the most part. So you just pull up the rules, they're all on the website. And then it's like it's a private proceeding for the most part. So it's not as strict as court. There's usually no motion practice in it. And so usually you're just doing depositions, and then ultimately you'll have an arbitration. It's one arbitrator. You can set aside 1 or 2 days. You usually have to submit materials in advance. So what we do is we would generally videotape the treating doctor. You give notice of that to your adversary, so you have everything on video and or a transcript, so you can use that. Or you can bring the doctor in live. You can also agree amongst parties whether you want live witnesses or not. It's often a lot easier not to have live witnesses and just submit the transcripts and the reports. So there's some flexibility that you can work with, but generally it moves very quickly, and you can get resolution fast. I think, probably 75% of the cases that we arbitrate, no fault, SUM cases with the AAA, we probably settle those without it going to the arbitrator. So there's a high chance of settlement because both sides want to reduce their risk. But there's a lot more involved. Feel free to reach out to me if you're going down this road or in this road, and I'll be happy to assist you with it. So, Rose, if it's all right with you, I will touch briefly on the Uber American Transit situation, just to put it out there. And then let's get to these 35 questions with only half an hour left. And you do the math, just me reading the questions is going to take some time. So, folks, we're probably not going to get through all of it. I'm going to try and pick out the questions that I think are really on topic here for what we're talking about. There are some that aren't, but again, if we don't get to your questions, just reach out to us directly. I think we've given you 10 different ways to do so, and we're happy to do that. All right, so winding back to the first part of this series on litigation issues in rideshare cases, many of you know, and thank you for reaching out to Rosa and I, that there was a case pending at the time that had just been argued, I think, that day or the day after. Well, we got the decision on it, came out the other day. It's from Kings County Supreme, and basically it held that in that situation, in that case, Uber was off the hook. They were not vicariously liable for the actions of the driver. Now, Rose and I reviewed it. It seems like a sound decision. It cites other decisions. We still stick with what we said back in the first episode of the series, that a lot of it is going to depend on how you build your factual record. So in that case, if you read the decision, which is online, if not, reach out to us and we can get it to you. They basically said the plaintiff couldn't establish fringe benefits, control an employer relationship, set schedule, a set salary, many of the things that are required to establish vicarious liability. I don't know, and I can't comment. I don't know the plaintiff that handled it, and I don't know the record they developed. But I think that knowing that these cases are out there, if you have one, you should read all of them, and you should really have a plan of attack when you go in to question the Uber driver, to create issues of fact. And I think each case will be different, and you can still have success, but the tide is turning in Uber's favor for sure. So you can't count on that. Especially in New York City, separate out on Long Island and maybe in other states. We talked about that. Go find the video from the first episode that we did, I think, in October. Now, American Transit is also now been deemed insolvent. How that's going to play out in pending cases, I don't know. I don't know if anybody knows. But when you hear that the primary insurance company for taxi and livery vehicles in New York City is insolvent, that's not good. Not good for any of us, plaintiffs or defendants. It's going to just create lots of issues. And primarily what we have seen in our Uber cases is that the primary policy is always American Transit, sometimes Hereford or Countrywide or one of the other cab ones, but primarily you see whether it's a cab or a black car or a Camry or a Tesla, that the driver is driving with a primary policy for that vehicle and that driver with American Transit, and then using an Uber app. And in the cases Rosa and I and my firm that we've litigated over the years, generally you got to get American Transit to pony up everything before you can even have discussions with Uber. Now, obviously, that's going down the toilet, it looks like. It's going to be really, really hard. We'll probably come up with another CLE, and Rose and I will look into all this and come back to you in the months ahead on it. For the time being, my strong recommendation is all of you, all your loved ones, Anybody you know that takes an Uber ever in New York City? I raise my hand. I have a car. I have coverage. I still use Uber a lot in New York City. Make sure your own and your clients and your friends and your family's SUM coverage is up there. It is another reason that residents of the great state and city of New York really need to have good SUM coverage. With a $25,000 policy minimum and a $100,000 minimum for taxi and livery commission cars, TLC, that is now kind of disappearing from American Transit. All the more reason to have our own coverage, right? Our SUM coverage. Go ahead, Rosa.
Yeah, I just want to jump in one thing. So the news that came out that we read was they have not filed for insolvency yet, American Transit, but apparently they've been insolvent for years, and now the Department of Financial Services is encouraging them to go through the process. So it's coming. And just to piggyback on what Andrew was saying, the problem here is in New York City, and this is New York City, on the island, this is different because the TLC rules don't apply. It's only where the TLC rules apply. Those drivers need to have their own coverage, and it's the $100,000 minimum policy that they get, and that was the American Transit. So now you have your client is in an Uber, and let's just say American Transit now ends up being insolvent. Well, that is one of the definitions of uninsured under the SUM endorsement, if the carrier is insolvent. So now your client could make an SUM claim. However, as Andrew and I were discussing, the majority of people in the city who are taking Ubers back and forth, it's because you don't have a car. Or, you know, maybe you do have a car, but you don't have a lot of coverage. So again, this is all something you have to look into now, knowing that they have been insolvent. I'm thinking that this is a trigger for, even without the declaration from the Department of Financial Services. I'm wondering whether it's a trigger for people to file their own SUM.
And that would be fortunate if that's the case, because then you don't have to worry about coverage and fighting American Transit for years, and you can just go right after your own SUM. So we'll be testing that for sure in the first case that comes up. And again, we'll report back and let you know. Another practice tip, something in my 30 years of practice that I had not seen, that I only saw once, and I was surprised about 10 years ago. We had a nice elderly woman who was crossing the street and hit by a car with a minimum policy. And of course, doing as I have just suggested everybody do, I questioned her about coverage. She looked into it, and it turns out that she had been a lifelong New York City resident, never owned a car, never had a driver's license, but she had an SUM policy that kicked in, and it worked just fine. So I said, "How did you get this?" She said, "I don't know. My broker told me I don't have a car. I should have this to protect me if something happens. So I got it, and I'm glad I did." So speak to an insurance broker, but clearly you don't have to have a car. You can just get an SUM policy. I didn't know it. Most people probably don't know this. So that's something that is worth exploring, right, Rosa?
Yep.
Okay. All right. So let's get to questions with the remaining 24 minutes we have left. I will filter them and throw them to Rosa, and then we'll go from there. All right. First one back from over an hour ago from Stuart. He has a case where the wife of the insured is hit by a motor scooter in the crosswalk, knocked unconscious, serious injuries. Lots of bad injuries, $150,000 in medicals. And Stuart saying that the New York City law apparently is that if a motor scooter speed is 20 miles an hour or less and was less than 100 pounds, that the carrier doesn't have to cover, and potentially that no fault would not kick in as well as the $25,000 SUM coverage that the husband purchased. Have you ever had a situation like this?
No, I never heard of that, and I would like to see this New York City law and how it reads, because is it saying that at the time of the accident, it was going less than 20 miles per hour? Because like that is a question right there. Or is it saying that the vehicle, it's just impossible, it can't go over 20 miles an hour, that's how it was built? I'd just be curious to see what New York City law that is. Very interesting.
And I'm thinking, Rosa, that, and Stuart can clarify, you know, scooter, there's distinctions. So there's the kind that you stand on and hold the handles that you see mostly kids and lots of adults in the city, and you sort of push. And I think some of them have electricity and some motors. It's sort of the stand-up scooter. And then there's like a Vespa, which is more like a moped. So I think you're probably going to run into situations when it's the former, the sort of stand on with the handlebars, that is not going to be deemed a vehicle. Whereas the moped type scooter is going to be deemed more like a motorcycle situation. So again, the devil's in the details. You're going to want to see the law, you're going to want to see the policies and go from there. We haven't seen that situation. All right. Jason, thank you for letting everybody know that you found a company with affordable 1 million SUM coverage. Please post that if you haven't already. If anybody knows of companies that provide really good coverage, everybody make that call, up your SUM coverage. It's not a huge ticket item. All right. Bruce is saying, if you have a 300, 500 SUM and a 2 million umbrella, does the umbrella come into play after the 500,000 is used up?
All right, so just, I need more details. However, a 300 slash 300, 500, I'm assuming it's per person per accident. That, the way I would look at this, if it's a single, this one person is injured, after the 300 is exhausted, then I would think you kick into the 2 million, but the 2 million might get the offset of the 300, like we talked about before. Umbrella policies are different. They're not necessarily governed by the mandatory rules, but all the umbrella policies I have seen still carry that same SUM endorsement. So if that's the case, I would think that there would be an offset, and it would be, if it's 300, if it's per person, it would be after the 300. If it's multiple people injured, it would be after the 500. That's how I would think it would land.
All right. And Robert is asking, and this is something that clients are going to ask you, and they ask us all the time. How does the payout of an SUM claim affect the policy premiums going forward, right? So you tell your client, great news, you've got SUM coverage, we're going to go after your own insurance policy and get you compensation. And they say, what do you mean? Wait, don't go after my insurance. They're going to raise my rates. What's going to happen? So I don't, and I'll let Rosa chime in after me. I don't have a specific answer, and I don't think you'll find it where they say if you file an SUM claim, we're going to increase your rates. I think it depends on the company. I think it depends on your claims history. And generally, what I counsel my clients is, look, you've got a good amount of SUM coverage. You would be absolutely remiss not to pursue it. It's like any other insurance. When you have an insurance policy, when it's time to take advantage of the insurance that you've paid for and benefit from it, will they increase your premiums going forward? Possibly, but that increase in no way is going to be worse than if you were to go and take the policy limits or go after it. So I wouldn't worry about premiums, is what I tell the clients, but they often do, and ultimately it's going to be their choice. If they don't want to sue their insurance company, that's up to them. You have any other thoughts on that, Rosa?
Yeah, just that same thing. I mean, it probably will go up. I mean, everything goes up now, and the carriers are now canceling everybody. It's really a pretty difficult situation out there. If I get calls all the time, what am I supposed to do? My carrier's canceling me because I've had too many claims. I've had 3 claims, and and then nobody wants to pick you up either. So it's becoming increasingly difficult. Yeah.
If you're joining us via podcast, the second attendance verification code is SUM004. Again, that's SUM004.
All right. Ji Zhang is asking for Lyft or Uber drivers, the drivers, not the passengers. Is it correct that SUM coverage for accidents that happen in the 5 boroughs is only 25,000?
My understanding from looking at the endorsement in Reg 35D is that they can't recover at all.
Anything.
So
right?
I'm not sure what that 25,000 came from, but that's the way I read the SUM reg.
Yep. So again, you're going to want to always look at the policies. Not the endorsements are the same, but look at the policy language and see what it says. Okay, Andrew is saying, here's the scenario. Tortfeasor is making a personal contribution. The amount contributed he believes is also offset from the SUM payout. However, if there's a punitive damage or cause of action for which there's a personal contribution from the tortfeasor, would that avoid the offset?
That's an interesting question, because the way the offset provision reads is it's an offset of all amounts received. And I have to find it, but it's an offset for all amounts received from the bodily injury liability. And I have to find it, and I apologize, I don't have that right in front of me. It is probably here. You know, you can contact me after. One of the things I do know, and that's why I'm hesitating, is if for example, you have in a situation where there's SUM case and there's a tortfeasor that pays, but then there's also, for example, like a municipality was negligent because like the timing of the lights was wrong. I know that the amount that they receive from the municipality is not an offset. And that's why I'm hesitating to answer your question. So that's a good question. And I'd have to look at the actual phraseology again of the offset language, which is just not popping up as I'm looking at it right now quickly. But you might be correct, that it is not an offset.
Okay, there's a few questions we've addressed about whether the clients are afraid if their insurance rates go up. You got to counsel them as best as you can, but ultimately it's their choice, right? It's their case. And if they tell you don't pursue my SUM insurance, what I would do is I would put something in writing to cover yourself from liability and say, to be clear, we had a discussion. You said do not proceed. We will not. We do not recommend this course of action. You're limiting your recovery. I would definitely put it in writing that you are recommending they do it and that you're abiding by their decision not to solely. Someone else is also talking about SUM as it pertains to Uber drivers who are the plaintiff. We just talked about that. Yeah, many clients don't want to pursue their SUM. You have to explain to them the pros and cons. And again, it depends. Are you looking for an extra 25,000 out of their policy, or is it a potential of another 6 or 7 figures, right? That's going to make a big difference. All right, here's a question Robert has. The client and defendant both have 25 policies. Client had 2 other claimants in his vehicle. They all had surgery. The defendant tenders 50,000, right? So it's a 25-50 for the defendant between the 3. It's kind of the fact pattern that we gave earlier. Since none of the claimants received the full policy, can they pursue the SUM claim? I bet you know the answer now if you were paying attention to us earlier. But Rosa, why don't you give the answer?
So they should be able to pursue SUM coverage. Again, it just depends on, again, like I said, it depends on if they're the passenger in the one vehicle that has the SUM coverage, or is it different SUM coverage? So again, you got to go back and really, really, plan out which person's entitled to coverage and which person isn't. Or even if they're entitled to coverage, you may not want to pursue it because there may not be liability on the part of one of the tortfeasors. So, as I said, it's a loaded question, but at the same time, they should be able to at least trigger the
Yeah, the trigger's there. So that's what you got to remember. It doesn't matter who gets what if the whole policy of the tortfeasor is exhausted, then it's triggered. All right, if you have enough coverage, SUM. All right, Jessica gives the following. It's a little long, but let's go through it because it's these fact patterns that we all see that are varied. So it's important to run these. All right, there's a chain collision with multiple vehicles. 3 vehicles, boom, 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 right? So vehicle 3, rear ends vehicle 2, rear ends vehicle 1. All right. Jessica's client's in the front vehicle, vehicle 1. Vehicle 3 in the back splits, hit and run. Okay. Plaintiff has soft tissue injuries. So that's the problem to begin with. The Geico policy of 25, I'm assuming that's probably from vehicle 2 because vehicle 3 split. They're offering you 15,000. Not a bad offer on a soft tissue case. If you don't think you can survive summary judgment, I'd recommend taking it, juice it up. You're saying the client has a 25/50 policy. Can you turn to their UM or SUM for anything additional? Continuing on, understanding there'll be an offset with the $15,000 offer. The UM carrier claimed that there's no UM since 1, there's no direct physical contact between vehicle 3 and vehicle 1 and 2, and that the Geico policy needs to be exhausted. UM carrier is not providing consent to go after the UM. Does the Geico policy need to be exhausted, and what to do if the carrier will not consent? Did you get all that?
I think so. Okay. So loaded question. So first of all, there has to be contact for a hit and run, right? For uninsured, for a hit and run, uninsured motorist. However, in this circumstance, the 25, the vehicle, the Geico, the one that's got 2550, if you're saying that vehicle is underinsured, then you should be able to recover just on the underinsured. Forget about the other car, forget about the uninsured one, the hit and run car. However, if that vehicle is not uninsured, so let's just say vehicle 1 and vehicle 2 both have 25K, obviously there'd be no trigger. If vehicle 1 has more and vehicle 2, you have to exhaust the full 25 before you can get SUM coverage. You can't just take their offer of 15 and try to offset it. So I hope I covered all that.
Yeah, so basically, Jessica, no, you're not getting SUM in this case. You're getting 15. And sometimes what we'll do as a practice tip is you tell the carrier, listen, I can't take a dime less than 25. There's SUM coverage here. So if you did have SUM coverage of more than 25, let's say you had 100, what we do in those situations is we say to the 25 policy, I need the whole policy. I know if it was just you and it was a one-on-one, maybe we'd resolve it for under the 25, save you something, take the 15. But I've got some good SUM coverage, which I can't go to unless I get exhaust your entire policy. I need the 25. Sometimes that works, sometimes it doesn't.
Right, and now that I'm looking at her question, she's saying the client has 25 on their policy and then Geico has 25. So there's no trigger.
There's no trigger
there.
Yeah, and it doesn't sound like your case is probably worth more if it's just soft tissue injuries, unfortunately. Okay, moving on to the next one. Andrew just mentioned a scenario where the client's driving the employer's vehicle in the course of their employment. What happens if the employer carrier claims the vehicle he was driving wasn't covered under the SUM coverage, but the deck page shows a $50,000 coverage and underlying bodily injury coverage is 25? Can I still pursue the SUM claim?
Okay, the deck page shows 50 coverage. All right, so in New York, you cannot have more SUM coverage than you have liability coverage. So something's, unless I'm misunderstanding the question.
Yeah, unless here's what I think is being asked, and so I'll try and take it. I think they're saying that the tortfeasor has 25 and that the employer has 50, but the employer's saying they don't have it, even though their deck page says they do. So it doesn't matter what they say, it matters what the law is. And if the policy is 50 and the tortfeasor was 25 and there's no dispute they were in the course of their employment, then yeah, it's a trigger and you can go after it under those circumstances. Okay, where are we next? There's so many great questions, everyone. I'm sorry that we can't get through to everything here. All right. We're going to go now to Matthew. Hey, Matthew, now that NYPD does not respond to motor vehicle cases, so I think what he's referring to is unless there's a serious injury, they don't want to show up and say they won't show up. What to do when the driver of the other vehicle provides bogus information regarding license and registration. There's no police report, and there initially is no report to the police of a hit and run within 24 hours.
Okay, so you can still go, your client could still go to the police department and try to report the claim. And I've seen that, and it's always, an issue because they don't want to take the claim and they don't want to take the report, but you only have to prove that you tried. And there's also, if you look at the SUM provision, it says something about to police or judicial officer. I'm not even clear what that is because I've never seen what a judicial or it says commissioner of motor vehicles. I think that's one of the provisions. So, I mean, it's probably too late at this point. I'm sure the accident didn't happen within 24 hours for you, but they can still go and try and report the accident themselves.
Yeah, I would still try it. All right, Catherine's asking if the driver that hit you is charged with a DWI and the insurance company denies coverage, is that an uninsured driver?
Where is she? What's her question?
Catherine it's at 1:30. The question came in.
Gotcha.
Driver hit you, defendant DWI, carrier denies coverage, is that considered uninsured then to go after SUM?
Well, once you get the denial of coverage, that's your trigger that it's an uninsured motorist. I mean, you're not there to decide their coverage issue. If your client has SUM, I'd file for SUM.
Yep, I agree, 100%. All right, David is saying that the plaintiff failed to commence a summons a complaint within the statute of limitations. Uh-oh. Can the plaintiff still claim through his UM policy of the 100,000? The other driver's insurance is 25. So the statute's run. Can you still go after the SUM, Rosa?
I doubt it because I think that you've breached your subrogation right by doing that.
Yep. And also they step into the shoes of the tortfeasor, and they've got a pretty good defensive statute of limitations.
Right.
So practice tip, never, never, never let a statute run, ever. File that summons a complaint well beforehand, serve it. If it's your case, don't say, oh, well, it's just SUM coverage, we'll just proceed against them. They said they'll look into it. No, always get that summons a complaint filed. You don't want to mess around and potentially expose yourself to a malpractice claim. Do you have to prove payment to the other claimants, lowering the amount available for your client before they can go after the SUM? So I think, Christine, what you're saying is, do you have to show that the other claimants got a piece and it was all exhausted before you can pursue the SUM?
Yes. It's my understanding you have to show payment.
Yeah.
They don't.
You get that from the carrier. They'll tell
They
you.
usually don't even ask that though, because by the time you get consent to settle, then after that it's, but maybe, I'm not saying they can't, but I would get payment.
Okay. So what about if the defendant has a rental car, the driver has their own coverage, and the rental car is tendered and SUM exists above both?
So,
So this is, Barry's asking this at
oh, I
139.
see. What about the rental, when the driver has his own coverage, but the rental car has tendered?
So let's say I'm driving a rental car and I hit somebody. The rental car's got 25, they tender it, they offer the 25. I've got 100, but the injured party's got, let's say, 200 SUM.
So if you look at the priority of coverage, condition number 7, it tells you that if there's multiple SUM policies available, that the first one in line is going to be the one that of the car that you were a passenger in. And then the next one is going to be the car that they're the named insured. And the carriers are going to fight each other on who's priority. So it's easier to just go straight for the passenger, the car they were a passenger in first.
Okay. Paul is asking, can you confirm that the statute of limitations for commencing an action against the carrier under the SUM portion of the policy accrues on the date of settlement between the plaintiff and the defendant driver's carrier?
I believe it does. It's 6 years. It's from when it's triggered, right? So it's 6 years from the point that it's triggered. So not the actual accident, as you know. So yeah, I would say that probably that release is going to be the date.
Okay. Same person is asking regarding the statute of limitations for commencing against the carrier under the SUM. Does the statute of limitations of the state of the location of the accident apply? Because in the fact pattern, it's a Florida registered vehicle. Policy is issued in Florida. Plaintiff lives in New York, but the accident occurred in New Jersey.
Oh, that's okay. So
Fun fact pattern.
Usually the statute is going to be the where the policy is written. However, I don't want to say that 100% because, obviously there's going to be an analysis of who has the bigger contacts and everything else. However, I would say generally the policy is written in Florida. It's a contract. So the contract is governed by the law of usually where it was entered into. However, you should also look in the contract because sometimes it tells you what law governs.
My gut would tell me if it's a Florida vehicle and a Florida policy, you're probably going to be dealing with Florida, not New York or New Jersey. But again, since you do have a right in New York, well, here's my question for you, Rosa. In this fact pattern, although in New York you have a right to bring it to trial, litigate it in state court, civil, or go to arbitration, is that if it's a New York policy, if that's the accident in New York. What about the situation if it's a Florida vehicle and a policy in Florida? Do we have to look at the language of that policy and Florida's state law to see whether it's arbitration or
Yes.
litigation or both?
I think so, yeah.
All right. All right. 2 minutes left. So we're going to take one more question. All right. And I'm up to Nancy. So you get it. When can you go after or sue directly the insurer of an at-fault driver? If he's dead when you sue, if your vehicle is registered in a no-fault state and the policy was written there in Virginia, but the at-fault now dead driver has the vehicle registered and insurance underwritten in New York. How do you sue the dead driver's estate? Boy, Nancy, you sure packed a lot in here.
That's a loaded. Well, the only thing I'm going to say is the one thing I do know is that in New York, as a plaintiff, you do not have a direct right against the insurance carrier of a defendant unless you have a judgment that remains unsatisfied for 30 days. So you'd have to file a suit against this individual, get your judgment, and then you could do it.
And as far as suing the dead driver's estate, check out the EPTL sections. I don't know if it's 4.5. I just looked at it recently with my partner Jason Friedman on a case, and they talk about how to sue a representative when the tortfeasor is dead. So with that being said, I know we didn't get to everybody's, and I know Michelle's got to do her last minute bit. So reach out to us. We'd love to roundtable with you and your firm, do one-on-ones, email, and we'll see you next time. Happy New Year, everybody, again.